Very good evening, everyone. I am Serafina D'Souza. I am the project coordinator for Moneylife Foundation. It gives me immense pleasure to welcome you to this discussion on the new Companies Bill and SEBI's ordinance. And may I now invite Ms. Sucheta Dalal, founder trustee of Moneylife Foundation and managing editor of Moneylife magazine, to introduce Ms. Savithri Parekh.
Good evening, everybody. Welcome to this very interesting program. First of all, may I have the pleasure of welcoming our guests properly, Ms. Savithri Parekh. We are delighted to have her as our guest here. She heads the legal and secretarial practice at Pidilite Industries, so it means that she's both a lawyer and a company secretary. Then she's been with media, retail, she's been in private equity. She was a head legal and company secretary at VFS Global Services, has worked in the private equity fund of the Future Group. She did a stint, like I said, at Anand Bazar Patrika. Ms. Parekh focuses her skills and expertise in the area of corporate governance. She is a regular speaker. She's been a guest faculty at IIM Calcutta for over 10 years at the management development programs as well as the advanced management programs. With these words, may I invite Savithri to speak.
Good evening. It's my pleasure to be here today to speak on the Companies Bill 2012. Thank you, Sucheta, for inviting me for this evening. The Companies Bill 2012 has been a long-awaited piece of legislation. Of course, it is yet to see it being enacted and become an act. And after the President's assent is received, this would become an act and a piece of legislation which we would have to implement. But there are far-reaching changes which have been made in the new Companies Bill 2012. If you look at the Companies Bill 2012, there are many changes which have been introduced, and the two speakers here, we've decided to allocate few topics to each other and therefore to avoid an overlap. And I would therefore be focusing on four main areas which are with respect to corporate social responsibility, mergers, the short form merger, amalgamation, shares of dissenting shareholders, and provisions with respect to sick industrial companies. Of course, there are other miscellaneous provisions. If we do have time, I would like to speak on them too. These are the various topics that would be covered in the session today. If you look at the provisions of Companies Act, presently, a shareholder gets information either from the various returns filed by the company or from the director's report, the board report, which is sent to the shareholders, or from the website of the company, or it may be an issue-based communication, which keeps happening whenever there are specific issues which are considered by an organization. If you look at these four specific provisions, the new Companies Bill has brought in a lot of transparency in dealings by making companies disseminate information in a clear, lucid, and transparent manner to the shareholders. Annual return, which is one of the returns filed by the company on an annual basis after the annual general meeting, presently contains details with respect to shareholders and changes in the shareholding pattern, transfers which have been effected in the last 1 year, indebtedness of the company, the top 50 shareholders, and the like. But under the Companies Bill 2012, every company will also be required to give details of remuneration of the directors and key management personnel, penalty or punishment which has been imposed on the company, which will also include compounding applications made by the company under whichever act and under whichever law that may be. The certification of compliances given by a company secretary in practice will also be covered in the annual return which the company would be filing with the registrar of companies. Details of shares held by FIIs are also required to be given in a little more detailed manner. And the director's report has also undergone significant change, and details of annual return, few of the features of annual return are also required to be now contained in the board report to the shareholders. Number of meetings of the board, which presently is covered under the corporate governance report, will also form part of the director's report. Of course, companies would refer to the corporate governance report rather than give these details in the director's report. Statement on declaration of independent directors. Independent directors are required to comply with various provisions of the Act, in particular with respect to proving their independence, confirming their independence, that is to avoid any conflict of interest. This declaration, which would be given by the independent directors, is required to be covered in the director's report as a statement on a statement of confirmation of the independent directors. Policy on directors' appointment and remuneration, including positive attributes of the directors, independence, and other matters. Explanation on qualification. This is a very, very important point. Of course, we do have something similar in the present Act, but at the same time, this has enhanced the scope by stating that the explanation on qualification or reservation or an adverse remark which has been made by an auditor, which is presently there in the present legislation, what is sought to be covered is any other company secretary in practice, that is a secretarial audit which is done by a company secretary in practice, will also form part of the director's report, and qualification in the report of the company secretary in practice will have to be explained in the director's report. And the report of the company secretary in practice will cover all areas of compliances under the provisions of Companies Act, and if there are any gaps, those will automatically reflect itself as an adverse remark of the secretary, of the company secretary in practice, and this needs to be addressed in the director's report, which actually means a secretarial auditor's report is placed on the same footing as that of the statutory auditor, and the director's report will need to give necessary explanation, which is a move towards ensuring compliance and disseminating proper information in a manner which would be easily understood by the shareholders. Particulars of loans, guarantees, and investments. The present section 372A, in line with this, any loan or any guarantee which has been given by the company, investments made, disclosure has to be given in the director's report, maybe in the form of a statement. All related party transactions which are presently covered in the notes to accounts, there would be a para on related party transactions in the director's report. Statement showing development of CSR policy as well as implementation of CSR policy will also have to be covered. This is, of course, CSR has been much spoken about, and I also would have something to say on CSR in a short while. And the policy initiatives of the company will have to be disclosed in the director's report. The constitution of the CSR committee is also required to be disclosed. In fact, the CSR initiatives are covered in the business responsibility report, which is mandatory for the top 100 companies presently. But this is something which all listed companies will now have to follow once Companies Bill 2012 is enacted. Manner in which formal evaluation has been done of the directors and of the committees and as well as of the board as a group will also have to be disclosed in the director's report. You would find that the contents of the director's report has changed considerably, and apart from the routine items which are now required to be disclosed, these are additional disclosures which are required, which is more like a detailed report card at the end of the year, which the board will have to present before the shareholders. All these pieces were available at the different places in the annual report earlier. Few of these, of course, are completely new, and few others were available on the ROC websites, the MCA website. But it has now consolidated all the information together, and it's given at one place in a manner which is easily readable by the shareholders, and it would be then placed at the AGM. That's with respect to disclosures. Moving on to insider trading. We do have provisions of insider trading in the SEBI guidelines and SEBI Act presently, but Companies Bill 2012 has specifically covered a section on insider trading, and it says that no person, including a director or a key management personnel, may indulge in insider trading. And insider trading is defined as something where a person trades based on unpublished information, or where a person takes advantage with respect to a price-sensitive information which is otherwise not available to the public. Today, the term price-sensitive information is not defined. And price-sensitive information, one would refer to provisions of the listing agreement where clause 36 requires a company to disclose certain events to the stock exchange immediately on the occurrence of the event. Clause 36 also does not define as to what event would amount to materially price-sensitive information. It only gives few examples which are therefore considered to be price-sensitive. It's more like few examples which are per se price-sensitive. For example, an amalgamation or an acquisition or any information relating to takeover is considered to be per se price-sensitive. But other than this, there are no specific guidelines as to what would amount to a price-sensitive information. Let's say, for example, a large company with a turnover of around 10,000 crores purchases a brand, which is an acquisition of a brand which costs, let's say, 15 crores. Is it price-sensitive information? One does not have a clear yardstick to cover this. However, a well-managed company would make a disclosure all the same. It's not about a disclosure which is mandated by the stock exchange or by the SEBI, but it's a question of letting your shareholders know and giving them the option to decide as to whether it is price sensitive or not. How much of information would you want the shareholders to know is something which is left to each individual company to decide. However, with respect to price sensitive information, there are no specific guidelines even today. So this is something which companies will have to be very, very careful to ensure that they're not caught on the other side. Contravention with respect to insider trading is very, very stringent in new law. It's imprisonment up to a term of 5 years, fine of 5 lakhs, minimum fine of about 5 lakhs, which can go right up to 25 crores, or 3 times the amount involved, 3 times the amount involved in profits, whichever is higher, or it could be both, imprisonment as well as fine. In fact, on insider trading, this is of course, SEBI has decided few cases of insider trading in the past, but we've of course seen the case of Rajat Gupta where the fine imposed was about $128 million, which is a whooping sum. Compared to that, these fines seem to be a small amount, but 3 times the amount involved is a reasonable way of making a beginning there. Having said that, in the US, SEC is very, very active on insider trading cases. In the year 2012, there were about 58 cases that were launched against 131 individuals by SEC. And the amount involved was around $600 million US. That's the kind of money that one is looking at if a regulator is very serious about prosecuting on insider trading cases. Generally, the cases of insider trading relate to buying or selling of shares before making a public announcement, unpublished information. And this is generally indulged by financial professionals or hedge fund advisors or sometimes even doctors, because they are the persons who are privy to some information which comes casually. And any information, any communication which is otherwise not available cannot be passed on by the directors. So there is a huge obligation on the directors, as well as the liability is also quite substantial. If you look at the rights of minority, if you look at the entire structure of company law, basically, in a listed company, you would have individual shareholders who hold shares in the company and would like to partake in the growth of the company and hold their shares as long as they would want to. If, for any reason, the functioning of the company is not in a manner which is considered as desirable, a shareholder always has an option to exit. At the same time, if the company goes in for a merger or an amalgamation which involves swapping of shares, and if the dissenting shareholders do not wish to continue with the company, they should definitely have an exit option. This has been clearly recognized in the new bill. Even presently, there is a provision, but at the same time, it's not as strong as it has been proposed. There's a compulsory exit option which has been provided in the new companies bill 2012. It was not a compulsory exit option which was available earlier. It was left to the discretion of the court. So here, when there is exchange of shares or a purchase of shares in a scheme or arrangement, the dissenting shareholders would have the right to sell their shares, and the transferee company would necessarily have to buy their shares. The dissenting shareholder here is a person who has not agreed to the scheme, or a person who has not communicated his consent to the scheme. So such a person would have an exit option to sell off the shares to the transferee company and opt out of the company. The same option is also available in case of a takeover. Now, in a takeover, where the acquirers or the persons acting in concert have acquired more than 90% of the share capital of the target company, the remaining shareholders would be given an option to opt out of the company. This is in line with international practice. In fact, it's also called an option of squeeze out. In Germany, if 95% of the share capital of a company is acquired by one group, then they would have to give an option to the remaining 5%, so that the remaining shareholders get a chance to opt out of the company. In UK, the threshold is 90%, very similar to what we followed in India now in the Companies Bill 2012. And in USA, the limit once again is 90%. But in the US, the shareholders do not get an option. The consent of the shareholders is not required. In India, consent of the shareholders is required for such an option. The new Companies Bill 2012 also provides for an increased price to be given to the minority shareholders. Say if the majority shareholders do a price negotiation whereby they agree to a higher price being paid to them, then the minority shareholders would get the further amount. That is, if the majority shareholders, if the takeover is done at X price and the majority shareholders get, let's say, X plus 10% additional, then the minority shareholders whose shares have been offered to the company but where the transfers have not yet got completed will get the additional 10%. So the interest of the minority is fully protected even in the case of a takeover. One of the features which is prevalent in most countries overseas, which was not present in the Indian Companies Act of 1956, is one of a quicker form of amalgamation. Once a matter goes to court, a scheme or arrangement takes a minimum period of 1 year. Even if there are no objections, even if it's a holding and a subsidiary company, it takes at least 1 year, and there are too many formalities to be completed. Under the new Companies Bill 2012, there's a provision for short form amalgamation, that is, where two or more small companies wish to amalgamate, or where there's an amalgamation between the holding company and its subsidiaries. One can opt for a short form amalgamation, which is fairly quick and does not have a very detailed procedure to follow. However, in case of short form amalgamation, the central government or the registrar or the official liquidator may raise an objection if there are specific issues which are of public interest. Otherwise, I would say that about 90% of the cases of short form amalgamation would just go through without any objection. It requires 90% of the shareholders in value as well as the creditors to approve the amalgamation. One of the important changes which has been introduced in the Companies Bill 2012 is one of corporate social responsibility. India is one of the countries where corporate social responsibility has been mandated in a statute. All other places, it's more of a company's option where the company decides to do something generally as a corporate citizen rather than as something which is mandated by law. In fact, if you look at the business responsibility statement of few of the companies, for example, Tata's have spent around 3.3% of their net profits in the last 1 year. Nestle's spent around 1.8% of their profits. Most good, well-managed companies have been spending around 1.2 to 3.5% of their profits in corporate social responsibilities. The new bill mandates a compulsory expenditure of 2% of the average net profits for the last 3 years. Of course, this is compulsory only for listed companies with a turnover of over 1,000 crores or net profit of over 5 crores or where they have a net worth exceeding 500 crores. Corporate social responsibility in the new bill has adopted a very different approach. It's one where the government looks at companies playing a role in the development of communities in the areas where the companies operate. Rather than looking at just expenditures being incurred by the company in whatever initiatives that they wish to do, the CSR initiatives have to be specifically with respect to the areas covered in Schedule 7 to the company's bill. Of course, Schedule 7 covers certain areas which are of immense importance, like with respect to alleviation of poverty, hunger, or empowerment of women, and so on and so forth. Also with respect to education and any other area that may be notified by the government from time to time. In fact, some of the companies overseas have adopted a very different approach with respect to corporate social responsibility, where they participate in community initiatives. Tyson's Food in the US had run a very unique program where they had promised to set aside 1 pound of chicken for every comment that they received on their website. And they received about 658 comments in a matter of 2 hours. And this Tyson Foods, which was engaged in a retailing business, they immediately dispatched 658 pounds of chicken, which was to be used for feeding the poor. Of course, there are innovative approaches adopted by different companies, including Häagen-Dazs, where they've started an initiative to spread awareness among general people on the importance of the honeybees. Honeybees are disappearing from the world, and therefore Häagen-Dazs has been creating awareness programs saying that this needs to be protected and preserved. So there are different initiatives which have been undertaken, but if you look at the new companies bill, there are specific areas which clearly shows that the government wants the private sector companies to participate in the development of the economy and play a developmental role. With respect to the obligation of the board will have to approve the CSR policy. CSR committee would have 1 independent director at least. Content of the CSR policy will have to be placed on the website. Expenditure should not be less than 2% of the average net profit. And most importantly, preference to the local area where the company operates needs to be given. The activities cannot happen in a remote place. Sikh companies today are referred to BIFR under the Sikh Industries Companies Act. Today, sickness is defined based on the net worth, and erosion of net worth is the test that is used to determine whether a company is sick or not. But once a company goes into BIFR, it is very difficult to get details of the company. For example, a company which has become sick may have a huge plot of land, and this plot of land may be worth a couple of crores. The shareholders have no way to know whether the company has assets which can be subsequently liquidated. In fact, when I was in the PE fund, I had an occasion to examine one of the companies, which was NBIFR, and I realized that it was quite a Herculean task getting details of the company because none of these are published information. While it is a company, you do not get any information on the company, save and except that it's a case which has been referred to BIFR. The test under the new companies bill for determining whether a company has become sick or not is very different from the one given under SECA. It's not based on net worth or erosion of net worth. It is based on inability to pay debts. That is, if more than 50% of the secured creditors apply for a company to be declared sick because they've not got their money within a period of 30 days from the time they send a notice to the company, then the application can be made to the company law tribunal, national tribunal. The company itself can also make a reference to NCLT for declaring itself sick, or a reference may be made by the central government. 75% of the secured creditors in value need to approve, but if the secured creditors have already referred the matter to Securitization and Financial Assets Reconstruction and Security Interest Act, SURFACI Act as it is called, of 2002, then the proceedings before NCLT would be stayed. This actually shows that there is a clear talking to between the two pieces of legislation. Rather than looking at it in isolation under the provisions of Companies Act as proposed, the Companies Act as well as the SURFACI Act would have a lot of interaction, and people would know as to what exactly is happening. SURFACI is generally invoked by public financial institutions or by banks. So if the secured creditors have already moved one agency, then the proceedings before the NCLT would be stayed and stopped. Revival schemes will need approval of the creditors, and the unsecured creditors also need to approve, but if 1/4 of the unsecured creditors approve it and the majority of the secured creditors approve the scheme, it will be sufficient for the scheme to grow through. This is basically with respect to revival schemes which would be considered for revival of the company. If the scheme is not approved, then the company will have to be wound up. The Companies Bill 2012 also provides for a rehabilitation and insolvency fund to be created, which would have credits from the government, monies given by the companies, grants given by any other source, and income from investments of the fund. Now, the monies which are paid by the company into the fund can be withdrawn if a company subsequently becomes sick. And the money that is withdrawn would be used primarily to pay off workers' dues. So this is done to ensure that to some extent the workers' dues are secured. Other amendments to the Companies Act which are proposed under the Companies Bill of 2012 relate to nomination. Presently, when shares are nominated, there's always a dispute between the nominee, as per the records of the company, and a person who's named as a beneficiary under a will. And there is generally a court dispute where the company also becomes a party to the dispute, because nomination vis-a-vis a right of a person under a will are tested by the courts. The Companies Bill 2012 very clearly settles this dispute and has provided that with respect to a nomination will clearly prevail. And this is overriding. This has an overriding effect, and therefore, if a nomination is made with respect to shares, this would be final, and no other person would be entitled to challenge it. Between the two legal heirs, they may fight it in a court of law, but the company would definitely not become a party to it. Further disclosures and director's report, which were explained by me, change in shareholding of promoters and top 10 shareholders is required to be disclosed to the registrar of companies, and this is required to be filed within a period of 15 days. Any change in promoters' holding is required to be disclosed to the stock exchange, and now there's a further obligation to disclose it to the registrar of companies too. AGMs can be held on any day other than a national holiday, anytime between 10 and 6. Director's responsibility statement, the director's responsibility statement, which is presently covered, has been made a little more elaborate. There are two more important provisions which will now be covered. One, that the directors have laid down internal financial controls to be followed, and and these internal financial controls would be sufficient for the company. This is a very big obligation which is placed on the directors. And that the directors have also devised proper systems for ensuring that there are no frauds in the company. Deposits which are accepted by the company from the public now need to be secured by way of a charge. This is a very big deviation, and it is a very, very welcome move, because a deposit is generally an unsecured debt which is with the company. And as an unsecured creditor, depositors generally do not get anything from the company except for the insurance, which if at all there is. But now all these deposits will need to be secured. What needs to be seen is the class of assets over which security would be permitted, which would be announced in the rules. And the term deposit has also been defined to include any kind of amount that is accepted from the public. Earlier, the term deposit was not defined in the Companies Act. It was defined in the acceptance of deposit rules, which had a lot of escape routes also, which has now been completely plugged. Maximum number of directorships originally under the provisions of Companies Act was 20, which was subsequently reduced to 15. But this 15 did not cover directorships of private companies, unlimited companies, and Section 25 companies. In the new Companies Bill 2012, this limit is at 20 companies, including private companies, unlimited companies, and Section 25 companies, other bodies corporate. And directorships in public companies cannot exceed 10 out of this 20. Special notice can only be given by a member holding 1% of the shares or share value exceeding rupees 5 lakhs. Stakeholders Relationship Committee as well as CSR Committee are two new committees which a company would be required to form. And Stakeholders Relationship Committee is required if a company has more than 1,000 shareholders. Merger of foreign companies with Indian companies is now permitted. You would recall that Bharti Airtel was in talks with a company based in South Africa, MTN, and they were looking at a merger, an option where the Indian shareholders could have got shares of the foreign company and vice versa. Of course, the deal fell through, but at the same time, this would not have been permissible under the old act, probably taking a clue from, in this case, merger with a foreign company has also been permitted. Special courts have been will be constituted under the new bill, and this would ensure speedy disposal of cases. They would basically be of the rank of a sessions court for trying offences under the Act. To sum up, the new bill provides for greater autonomy for the companies to function. They don't need to go to the central government for every issue. Like, for example, related party transactions, 297 presently mandates the company to go to the central government for seeking permission. Such permissions have been done away with. Self-regulation, more of regulation by the company and based on positive assurances. Transparency and better disclosure. Greater responsibility on the board and the directors, and focus on compliances. Thank you very much.